everybody, in this lecture we are still busy looking at companies and the Companies Act, and we will focus specifically on capacity and representation. Capacity and representation as regulated by the Companies Act, but then also by the common law principles of constructive knowledge, ultra vires, and the Turquand rule. In this lecture, we will focus on the Companies Act, specifically pertaining to a company's legal powers and capacity to act in terms of Section 19 of the Companies Act, and the impact and consequences of Section 20 on the company and the third party. We will also investigate the common law principles of ultra vires, the Turquand rule, and constructive knowledge. Section 19 of the Companies Act specifically states that a company, from the date and time that the incorporation of a company is registered, that the company is a juristic person and that it has all of the legal powers and capacity of an individual, except to the extent that a juristic person is incapable of exercising such power, or the company's memorandum of incorporation provides otherwise. So what are some of the main elements from the previous slide that we need to look at? Firstly, that a company is a juristic person, and we know this. We know a company has a separate legal entity from its members and that it has a number of consequences, which we have focused on in some of the previous lectures. We also see that a company as a juristic person has the capacity to act. But a juristic person cannot act all by itself. It needs an agent to act on its behalf. And who is an agent? An agent is someone who is duly authorized to act on behalf of the company. And this can include the directors, the representatives from the legal department, the company secretary, etc. Then we see Section 19 also provides for two exceptions. Two instances where the juristic person does not have the capacity to act. The first exception is when the juristic person is incapable of acting. And this often relates to inherently human actions. For example, a juristic person cannot perform the inherently human action of drafting a will. Also, when the memorandum of incorporation provides or excludes certain capacities to act. So, what are these exclusions then, as stipulated by Section 20 of the Companies Act? Section 20 tells us that if a company's memorandum of incorporation limits, restricts, or qualifies the purpose, powers, or activities of the company, then no action of the company is void by reason only that the action was prohibited or as a consequence of this limitation. Now, what does this mean? What does Section 20 tell us? Previously, Section 19 explained to us that a company upon incorporation, becomes a juristic person with the capacity to act, except if it is incapable of acting or if the memorandum of incorporation limits, restricts, or qualifies this capacity to act. And now, in Section 20, we see that even if the memorandum of incorporation limits, restricts, or qualifies this capacity to act, it does not mean that this act is then void only because the memorandum of incorporation prohibited this act or any consequences flowing from this act. So it means that a contract will remain valid and binding on a company and the other party, even if the company or the agent of the company did not have the capacity to act on behalf of the company and to enter into such a contract. So what are the consequences of Section 20 on or for the company? So in other words, where the agent acted or acting on behalf of the company entered into a contract with a third party, but the agent did not have the authority to do so because it was specifically excluded or restricted in the Memorandum of Incorporation. Then there are three possibilities. The shareholders can decide to ratify, so to retrospectively agree to this contract, as long as this contract is not against the Companies Act. Or if this will still take place in future, the shareholders, directors, prescribed officers, or the trade union representatives can get a high court order to prevent this agent from entering into such an agreement or such a contract with a third person. Or the shareholders can claim damages for any act that was inconsistent with the Act and the Memorandum of Incorporation. And if such an act was a fraudulent act or because of gross negligence, then the shareholders will have a claim for damages that they suffered because of this fraudulent or negligent act that caused this agreement or contract to come into existence. In the previous slide, we said that the consequences of Section 20 for the company would be either to ratify, to retrospectively agree to this agreement or to this contract, or to, if the contract is still in the process of being entered into, to go to the High Court and to get a court order to stop it. Or if the shareholders suffered any damages because of this agreement that was entered into fraudulently or based on gross negligence, they have a claim for damages. So what is the impact of Section 20 then on the third party who entered into this contract with the agent that did not have the authorization to enter into such a contract? Well, if such a third party entered into this contract in good faith, and this party is someone other than a director, a prescribed officer, or shareholder, so in other words, someone outside of the company, this third party is entitled to presume that there was the necessary authority to enter into this contract. And unless the person knew or reasonably should have known that there was not the necessary authority, this contract will be binding. So let's summarize. What is the consequences of Section 20 on the company and on the third parties? For the company, the shareholders can ratify, so retrospectively agree to this contract, or can get a court order to stop this contract from happening, or then claim damages if this was entered into fraudulently or with gross negligence. The third parties, unless they specifically knew or ought to have known, have the right to presume that the necessary authority was there. And if they suffered any damages, they can also claim damages from the company. In the common law, we have similar principles to Section 19 and 20 of the Companies Act. So let's use the example of the company's memorandum of incorporation, specifically outlining the procedure for appointing directors. But the board then continues to add or remove directors without following those procedures. Then those actions by the board will be described as ultra vires, or beyond the powers of the company. So when directors, for example, exceed the limits of their authority, for example, they lack the authority to conclude a particular transaction because they are specifically restricted from doing so in the memorandum of incorporation, they will have acted ultra vires, or beyond the powers that they have and beyond the powers of the company. The company, though, will remain liable even though the directors exceeded their limits of authority, so they acted ultra vires. The company will remain liable to that contract. Now, the doctrine of constructive knowledge attempts to protect the company from the third parties or the outsiders. And according to the doctrine of constructive knowledge, the memorandum of incorporation and articles of association are open and accessible documents to everybody. So there rests a duty on the third parties dealing with this company to inspect these documents and to confirm whether certain actions are within the company's powers. So whether the company indeed has the authority to enter into a proposed contract with a third party. And when entering into such a contract, the third parties are presumed to have knowledge of the content of these public documents. So every person dealing with a company is therefore treated as having knowledge of the content of the MOI and the Articles of Association. So in other words, having constructive knowledge of whether a company indeed has the power and authority to enter into a proposed contract with the third party. In the previous slide, we said that the doctrine of constructive notice dictates that third parties have access to the memorandum of incorporation and articles of association because these are public documents. And so there rests a duty on the third person or the third party wanting to enter into agreement with a company to make sure that the company does have the necessary authority or power to enter into such a contract. But what happens if a specific agent did not have the authority to enter into a contract with a third party, but the third party was not aware of this? The third party entered into this agreement in good faith, thinking that it is indeed in the power and authorization of the company to enter into such a contract with the third party. So when the court needs to decide whether to hold a company bound and liable, when a contract was concluded between a company's representative and the third party, and the specific representative did not have the authorization, the necessary authorization to enter into this contract with a third party, because there was not specific authorization obtained for this specific contract, or there was an irregularity in the internal procedures of the company, not giving this representative the necessary authorization, then the Turquand rule comes into operation. The Turquand rule stipulates that unless a person knew or reasonably ought to have known that a specific director needed special authorization from an internal formality, and this outsider or third party is dealing in good faith with the company, then this third party may assume that the necessary authorization has been obtained. So the Turquand rule protects the third party in instances where specific authorization by the company's representative had to be obtained, or there was an irregularity in obtaining it, and it was, in other words, not obtained, and therefore the company's representative did not have the authority to contract with the third party. Then the Turquand rule will stipulate that the company is still bound and liable to the third party because the third party acted in good faith, and they have the right, according to the Turquand rule, to assume that the representative had the necessary authorization. So in this lecture, we focused on the Companies Act, specifically pertaining to sections 19 and 20. Section 19 explaining the legal powers and capacity to act of a company, which becomes a juristic person upon incorporation. A juristic person with all the capacities to act, except if the juristic person is incapable or it is specifically restricted by the Memorandum of Incorporation. Then we also focus on Section 20 of the Companies Act, which stipulates that even if an action or the capacity to act was restricted in the Memorandum of Incorporation, it does not make that contract void or unenforceable. We focus on the effect of or consequences of Section 20 then on the company and then on the third party. We said if the contract was entered into without the necessary authorization because it is restricted by the Memorandum of Incorporation, then the shareholders can still ratify or retrospectively agree to the contract, and then the contract is of course viable, it is enforceable and valid. Or the shareholders, directors, representatives can stop this action, this entering into a contract with a high court order, or then if damages were suffered by the shareholders because of gross negligence or fraudulent behavior, then they have a claim for damages. In terms of the third party, if the third party entered into this contract for which the company was not authorized to enter into, but entered into this contract in good faith, not knowing, not supposed to have known that there was not the necessary authorization, this third party will also be bound to the contract, and the company will be bound to the contract, and the third party, if suffered any damages, can then claim also for damages. Then we looked at the common law principles pertaining to the same kind of issues, the issue of representation and of capacity to act. We said that sometimes the company acts outside of its authorized powers, and that is called acting ultra vires, outside of the authorized powers. Then sometimes a third party enters into a contract where the representative did not have the necessary authorization because it was not obtained from within the company or there was an irregularity within the company. Then, according to the Turquand rule, the third party, if the third party acted in good faith, has the right to assume that the necessary authorization was there, and therefore the contract will still be valid and enforceable. We also saw that the third party also has the duty to make sure that because the Memorandum of Incorporation and Articles of Association are public documents, the third party needs to make sure that the company it wants to enter into a contract with does have the necessary capacity and authority to enter into such a contract.